And we're live. I hope you didn't hear that last line that Kate said before we went live, because it would be weird. But if you did, fine. It is Monday, June 15th, 2020. We were sitting around this morning thinking to ourselves, what, oh, what are we going to do on the show today? Because we don't have a guest. And actually, the plans for guests tomorrow kind of fell through a little bit too, because I found out that, dear viewers, I have been misinforming you. When I told you that there was going to be a Michael Flynn hearing in the district court on June 16th, I was wrong. It's July 16th. So we had gotten as far as planning a show based on a 1-month error. And we were sitting around mopping our brows with grief this morning as we contemplated, what are we going to do today and tomorrow, when all of a sudden 6 justices of the Supreme Court stepped in and solved our problem, issuing one of the more unexpected decisions from the Supreme Court, both in its scope and in its the numbers of justices who were on it, and in the fiery dissents that it produced, applying Title VII, the sex discrimination provisions of Title VII, both to sexual orientation and to transgender status. It is a 6-3 decision written by none other than Neil Gorsuch, over a virulently angry dissent by Justice Alito, who accuses him not merely of getting it wrong, but of betraying the legacy of textualism and Justice Scalia. It is really personal. And so, to discuss the importance of the case, the substance of the case, and the meta intra-conservative politics of the case, which are just, excuse me, frickin' delicious. We have Leah Litman and Anthony Kreis, Kate immediately wrestled up to discuss this today. So welcome to the show, guys. Thanks for bailing us out. Because between you and the justices, we actually have an awesome show today. Kate, why don't you introduce our guests?
Hey, first of all, below me, or it should be, I don't know if it's actually below me because I think that maybe it just flips over in YouTube, but we have Leah Litman, who I mistakenly promoted last time that I was on the show to an associate professor, but is actually an assistant professor.
She's an associate professor in our hearts.
Yes, exactly.
In the court of history, I'm an associate professor.
Yeah. And in the art of, where do you buy your cool t-shirts, Leah? This is a very good, very, very good t-shirt. I'm a very lazy person, but that actually seems like a very lazy way to make a statement while making a heck of a statement. I kind of love it.
So this is actually a gift, but you can get your own Katie Porter's Whiteboard Energy t-shirt on Crooked Media. Katie Porter is a fabulous former colleague of mine who I now just spend all the day fangirling over on Twitter.
That's so great. And you have a great Carol Baskin. Is that Carol Baskin?
So this is
Tiger,
and this is
God.
Joe Exotic.
Okay, so I was a little worried and was going to call you up short on being pro Carol Baskin, but now I feel better. And we can debate.
Yeah, you feel better because
this episode is about Justice Alito is the new Carol Baskin.
Because you got the guy who is certainly guilty of conspiracy to commit murder, rather than merely the woman who might be guilty of conspiracy to commit murder or actual murder.
That's true.
I don't want to get too controversial here before we've even gotten into the case. But then we also have Anthony Kreis, who's a wonderful, fabulous junior scholar and who is starting at Georgia State as an assistant professor this fall, which is going to be crazy, crazy fun times for all. And Anthony, you do civil rights work. And I can't remember I know that Leah does Voting Rights Act, but do you do Voting Rights Act too?
No, I'm pretty much strictly Title VII as far as federal.
That's what I thought. So when we kind of saw this case, I was like, oh man, I know the two awesome, fresh-faced sassy scholars that I want to talk to about this, who know what's going on. And also I was feeling a little bit bitter after having read Oren Kerr's recapitulation of his podcast with Eric Posner, in which Eric Posner apparently chastised just kind of dunked on every single academic on Twitter, and was like, they're really embarrassing themselves. He did it Mrs. Houlihan, Ben. He kind of Mrs. Houlihan everyone.
Yeah, except he didn't say, Kate, I'm really embarrassed for you.
No, but he kind of did.
He basically did. He's like, there's a bunch of people who always talk about all of these academics on Twitter who just say all of the stupidest things on Twitter and are making fools of themselves.
Yes, and he's like, basically, you say smart things, but you don't.
But that's different from saying to Kate in a high school class, Kate, I'm really embarrassed for you.
Yeah,
which
Eric
is what
Posner
Ms.
did
Houlihan
not send
did.
me an email.
By the way, I had a teacher who did something way worse than that. Not to me. She actually pulled my friend aside and said, Mike, I had a nightmare last night that my child turned out like you. And I think that is just the gold standard of teacher, like one sentence by a teacher that is, I don't know of any one teacher who has said one sentence worse than that.
That disabuses you of the notion of giving high school teachers tenure. Yes.
But also gives you just reminds you that there are some bad people in schools. Yeah, she was one of them. I'm not going to call her out by name because I think she still lives around here, and I don't it's my hometown, and but yeah, there's a bunch of people who she traumatized as high school students, and we're all together on Facebook reliving it every day. So to all the Mrs. Houlihans out there, let's talk about this case.
Yeah, guys, thank you so much for coming on such short notice and lending your expertise and your sass and your Katie Porter energy.
So, Anthony, get us started. How big a surprise is this? This, just to set it up, this is an issue on which I think all of the circuits had ruled the other way, except the Second Circuit. It is an issue that we first got an inkling that Justice Gorsuch might be sympathetic to the claim at oral argument, where he seemed to have a kind of textualist sympathy to this. But I don't think anybody was really expecting a 6-3 opinion that went the whole way. And so am I wrong about that? Or how big a surprise is this? And in your judgment, what's the nature of the surprise?
So, this has really been, 40, 50 years in the making. So the cases that, let's first off start off with the issue. So, right, the issue is whether transgender discrimination and sexual orientation discrimination are subsets of sex discrimination, because of course, right, the Civil Rights Act of 1964 only specifically says that you can't discriminate in employment on the basis of sex. So there is this question of, well, what is sex discrimination? Can you discriminate against someone because they're gay, they're bisexual, they're a lesbian, because they're transgender without taking their sex into account? Now, people have been trying to think about this in terms of, think about LGBTQ discrimination in terms of sex discrimination since the mid 1970s, and have brought these cases again and again and again and again and lost routinely. And in terms of the sexual orientation cases, they lost every single time from the mid 70s that they started bringing these cases up until 2016, 2017, when you started to get some movement from the EEOC, some district courts. And then in 2017, the Seventh Circuit became the first court to rule in favor of sexual orientation discrimination being a kind of sex discrimination and actionable under Title VII. And then very shortly after, the Second Circuit followed. So it was a pretty, we're talking about basically in the last 3.5 years, we have revolutionized the doctrine in terms of sexual orientation discrimination as it relates to sex discrimination. And the courts have just routinely, said no. Now, the transgender discrimination cases had a lot more success, and those have been pretty successful since 2004, a few before that, but there's been a lot more success for reasons we could get into later. So against that backdrop, I think a couple of things are incredibly surprising. I think it's one, a shock that both cases, the transgender discrimination case and the sexual orientation discrimination case, came out the same way, in the same opinion together. That, in light of the fact that you had decades and decades of precedent working against the sexual orientation cases in particular, that the court went the way it did. And I think I'm also just genuinely surprised that you had Chief Justice Roberts and Justice Gorsuch both in this mix. And because I thought Justice Kavanaugh might be more of a player because of some of his other views on textualism, which we can get into later. But I think ultimately, given how many years of precedent, or how many years in the making, this took, and given the conservativeness of this court, notwithstanding its, the commitments to textualism, which I thought were persuasive for the plaintiffs here, it was a huge shock, right? You get a 6-3 decision, and it just, to me, something I'm going to celebrate because I'm an advocate for it. But it's certainly not what I thought would happen, and not the margin by which I thought it would happen.
Leah, how much did this follow Katzmann's Second Circuit opinion?
It followed it somewhat, but I think in rhetoric and in other ways was much more formalistic, and also suggested some limits to the decision that weren't in Judge Katzmann's decision. So Justice Gorsuch made a point several times saying, like, well, where the express language of the statute is clear, we just don't care at all about extra textual considerations and whatnot. And then also, focused on some parts of the statute that I think figured less prominently in Judge Katzmann's opinion. The repetition of the word individual, was a big part of this opinion. And Judge Katzmann's opinion, I think, was focused more on, well, there's this line of cases that, Justice Gorsuch only got to in kind of the back half of the opinion that Judge Katzmann focused more on. And Justice Gorsuch also suggested some limits to his opinion that Judge Katzmann did not. So Justice Gorsuch, for example, noted that the defendants in these cases, the employers, had not argued that they were exempt from the Civil Rights Act because they had possible religious objections to the statute, and that those claims had not been preserved and were being reserved for another day. He also noted that this case did not resolve the propriety of rules about single gender restrooms or locker rooms. And I think those limits, also did not figure quite as prominently in Judge Katzmann's opinion, although I agree that they were not actually presented in this case. So I think both in methodology and tone, and also in noting some of the perceived limits, it was a little bit different, this opinion, than Judge Katzmann's. And I think this opinion followed more in structure and in tone of some academics who have, most notably Katie Eyer at Rutgers, who has basically framed this entire issue in terms of what she calls statutory originalism. And, how much do we care about the, public meaning of the words in the statute versus the expectation of the people who drafted the statute.
Yeah.
So I want to,
go ahead.
Sorry, go ahead, Kate.
I was just going to say that someone flagged Katie to come on the show, so she might be joining us in the bottom half of the hour. So if you guys have questions for her at all.
Well, great.
Yeah.
How does it feel to have your amicus brief adopted by the court without being credited? No,
wait, really? Wait, is that a thing that happened? What?
It's actually not uncommon, I don't think, like for the court to say, like, well, look, like we read these arguments, we found them persuasive, but like at bottom, they're kind of legal arguments about the better interpretation of this statute or better interpretation of precedent. So it's not at all uncommon, I think, for the court to adopt arguments that were floated in different briefs without saying, oh, we got these arguments or like noted them here.
Yeah, I think if you're an advocate before a court, being plagiarized by the court is the highest form of victory.
Yeah.
Leah, I wanna focus on this question of statutory originalism, because I think one of the most interesting things about this, the sort of subtextual that kind of rises into the surtext a few times, is that there is a real battle among the conservatives right now about what originalism means. And I think the anger of the man standing behind you is less about the outcome here than it is about the appropriation of originalist methodology in support of the outcome, though he may be very upset about the outcome as well. is Gorsuch's opinion defensible as originalism, or is Alito right that whatever the merits of it, it's not originalism? He's updating a statute. He's making a statute more presentable. I gotta say, when I read his opinion, I thought it was like dramatically more persuasive than I expected to find it. I had, you know,
You mean Justice Alito's or Justice?
No,
Gorsuch's?
Justice Gorsuch's. I mean, my sympathies are with the plaintiffs here, or the the employees. But I've never kind of doubted that when Congress passed the '64 Civil Rights Act, this was the last thing from on their minds. And I've kind of always assumed that you needed another statute to get to employment non-discrimination for transgender and gays and lesbians, which I'm perfectly happy to support. But it never really occurred to me that the sex language gets you there. It's obviously a closer question with respect to transgender than with respect to sexual orientation. But I kind of assumed I would pick up the opinion and say, well, that's good policy and bad law. And I read the opinion, I was like, holy shit, this is pretty persuasive. And so I was interested that Alito's defensiveness about it seemed to be about almost more on the subject of whether it was really originalism than it was on the subject of whether it was right. And so I'm interested in your views on this. Is it defensible as originalism, and is it right as originalism?
So a lot to say there. I'm not sure I totally agree with you that what Justice Alito is objecting to is Justice Gorsuch saying that is his methodology of textualism that gets to this result, because it's not like Justice Alito is some extremely avowed textualist or originalist. You know, he's kind of more of a pragmatist, but I do think he's very annoyed at Justice Gorsuch's opinion for reasons that I think are interesting to think about. I think Justice Gorsuch's opinion is right. And I think that the differences between the different opinions reflect different ideas about what originalism and textualism are. So originalism refers to the idea that we interpret the Constitution or statutes according to their original meaning, right? Like what they meant when they were enacted. But there are different audiences that you can ask, well, what did they originally mean as to that audience? And I think the Gorsuch opinion is saying, well, look, if you asked a group of people what the word sex meant, what the word individual meant, and what the word because of meant, they would say, right, because of, right, the sex that someone was assigned at birth. And when an employer treats someone differently, either because of sexual orientation or their gender identity, their treatment varies according to, you know, their own sex assigned at birth or like their partner's sex assigned at birth. And in some ways, I think the gender identity cases are kind of easier, right, in that way, than the sexual orientation cases. Now, I think for Alito,
but hang on a second. I can't take Alito seriously on this point. Because this would, if you take this logic seriously, it would do away with the sexual harassment cases too.
Oh, yeah.
Right? The sexual harassment cases aren't saying we won't hire women. They're just saying we won't hire women who won't sleep with us.
Right. No.
And, right. And so, like, if you're really saying because of sex means only what Congress in 1964 would have thought it meant, given, like, you're doing away with half of Title VII, right?
Yes, no, that's completely right. It's not just the sexual harassment cases. It is the cases where you had male plaintiffs suing to invalidate statutes that treated men worse than women, and you would be invalidating those cases too. You know, sexual harassment was, you know, a revolution in jurisprudence. And of course, people are going to see new applications of a statute beyond what was originally anticipated. But for Justice Alito, the original meaning of a provision is, what did the people who enacted it think it meant, right? What were its expected applications? And this is a tension in originalism and textualism, right? Like, do we care about what the core semantic meaning of a word is, or do we care about how people thought that legal provision would be applied? Justice Alito wants to do the second approach. Justice Gorsuch wants to do the first. I think the trend in originalism has been toward the Justice Gorsuch approach. Do we care about original public meaning? But there is a strong dissenting camp among both academics and conservative jurists who say, no, like what we really care about are expected applications, or at a minimum, expected applications tell us something about what the original public meaning is. And the divisions between the opinions, I think, very much reflect that.
Anthony, do you agree with that? And like, is that consistent with like how Title VII has kind of progressed through the courts?
So I think there's a few things. So the first thing is the federal government argued, and I thought the court might bite on to this argument, and thankfully they didn't. But the federal government's one of their main arguments was, well, you're not discriminating against men and women because men and women can both be homosexual, and therefore you're not. It's not really along the class lines of sex. But that's not consistent with what we know about Title VII, which one, it applies to individuals and not groups. So to the point that we were just talking about, there's one of my favorite cases to teach is a case where women with young children are not hired because there's a presumption that women with young children aren't going to be dedicated workers, and they'll be bad employees because they'll be focused on being mothers like women do. But of course, right, like that's a whole sex stereotype, and so the discriminatory act is not against all women; it's against a subset of women because of a stereotype that animates that decision making.
Or even better, right? The pregnancy cases, right? Where it was kind of like, there was the entire conversation about whether pregnancy was a sex, like a characteristic of sex, or whether it was actually like men couldn't get pregnant, but like obviously, but women, right? Am I misremembering this? I thought that there was like an entire.
But Geduldig, they said that pregnancy discrimination was not sex discrimination.
Yes, exactly. That it was not sexist. That's what it was. It was the other way around.
But
Sorry, I didn't mean to interrupt you, Anthony. But
there was, right. So there also was a Massachusetts Supreme Judicial Court decision interpreting Massachusetts state law that said, oh, well, of course, pregnancy discrimination is a form of sex discrimination because there were all of these stereotypes and things, that are inherently gender based. So, I don't think there's really any clear cut, right? I think there's this assumption with originalists in particular, and I'll get in a lot of trouble here, but there's an assumption with originalists that like originalism is like the end all be all because it is like, comes from the ether and there's some objective, easily discerned outcome that's neutral. And I think what this decision today and the dissent from Justice Alito shows is that that's not true. Like even within originalism, there are choices, and there are choices in how what vantage point you're using. I don't think there was any argument seriously from the plaintiffs and the employees here that you actually had to change the definition of sex as it was commonly understood in 1964 to get to the outcome you got to today. Because all the plaintiffs' employees were asking was saying, you can't look at my sex as it was commonly understood, men and women, whether a man or a woman, and not think about that when you're discriminating against me because of my sexual orientation or gender identity. You don't have to toy or kind of rework or remold that original understanding of what sex is to get to that endpoint. So I think this is very consistent with other Title VII decisions like the Phillips versus Martin Marietta case, and like some of the sexual harassment cases, and like Pricewaterhouse versus Hopkins with gender nonconforming. I mean, it's very consistent with that. Now, I think what we need to talk about is whether the language used, right, in the analysis, whether the formalism is consistent with some of those older cases and the principles that are derived from it.
What do you mean by formalism?
So there are a number of different avenues that the court could have taken to get to this outcome. So the first one, which the court essentially took, was you can't see me and discriminate against me on the basis of sexual orientation and gender identity without taking into account my sex, right? You can't disaggregate the two. And I think that's all well and good, fine. The second one, though, is a principle called sex stereotyping. So the idea there is if there's some kind of stereotype about how men and women should act and behave, right? If there's some kind of gender norm that's part of the calculus of an employer, that's also unlawful discrimination. And that's right. That's the core of this case, Pricewaterhouse versus Hopkins, where Ann Hopkins sued Pricewaterhouse because they said, well, we're not going to promote you because you're a little too rough around the edges. Essentially, you should wear more makeup. You should you use less coarse language, and you should act more like we think a woman should act. There could have been a way that actually the court looked at sex stereotypes and how sex stereotypes in gender works in the world to create a decision that was much more substantive in understanding the relationship between gender roles, societal expectations, sex, women's equality, LGBTQ equality, and really understood this in kind of like dignity terms, not to drag Justice Kennedy into this, but like, right, to really kind of validate the LGBTQ experience. That's not what happened today, right? What you saw today was a very, I think, vanilla, straightforward, plain application of the statute, which I think is a valid, right, one valid avenue, but that was another valid avenue. And a third avenue that we've often talked about in employment discrimination cases is this idea of association discrimination. So there are cases about, for example, interracial couples being discriminated against. And there's this big case from the early or mid 1980s in Atlanta called Parr, where a white man was discriminated against by white people who found out he was in interracial marriage with a Black woman, and they didn't like that, and so they discriminated against him, and they refused to hire him. And the argument was, well, we don't have a problem with him because we're white. We like white people. We just don't like what he's doing in the privacy of his home. But there's this whole argument about, well, or the court basically said, well, you can't, you're still, your association is protected, right? So there's this kind of idea that's imported from Loving versus Virginia and these other constitutional cases that says, well, Title VII, it was enacted to be a parallel, right, statute to bring some of these constitutional norms into the private sector, and so we're going to protect these associations. Now, I think that's also a much more trickier thing for the court to buy into. I didn't expect that, but there were other avenues in addition to kind of the straightforward textualism approach, which I think would be more true to history and more true to the LGBTQ experience. But that's not where this court is going. So I think in that sense, the silence of the liberals here is also as telling as the fights between Gorsuch, Roberts camp, and then the Alito camp on the other hand.
I want Ben, go ahead and ask. I just want to just set up really quickly. I worked in a number of Title VII cases in both the Eastern District of New York and then Second Circuit when I was clerking. My general the threshold for what class, like how you define the classes, is like one thing, but then there was the fact that like they, in general, it just seemed like a very, very, very high bar for behavior to qualify as having been sexual harassment or discrimination. Like remarkable, like, and anyone who, like, you guys know this, but I don't know if everyone who's watching knows this. So I'm just going to like say this, and I'm kind of interested in your thoughts on this. But there was, there were countless cases of people watching pornography, like men watching pornography, like supervisors watching pornography in front of their assistants or their secretaries, constant, like all of these kind of constant references, or like all of this kind of like harassment that or what I would consider harassment, but didn't rise to discrimination in Title VII context, which always left me feeling like even if you are a protected class among Title VII, that like it's not a particularly robust. It's not as robust as people think it is. Let's put it that way. And mostly people end up settling out of things don't get litigated because people don't want to go through discovery. I'm just curious if you can kind of color in some of those details about Title VII and what it means as a piece of litigation and a tool for people, and how this changes that, if at all. Yeah. And then I'm sorry, I kind of cut Ben in line for questions. So Ben, you're next. I apologize.
So I'm sorry, go ahead.
Oh, no, I just didn't know whether I should answer the question or...
No, go ahead, answer the question.
So just two quick things on that. The sexual harassment cases that you were talking about, those cases are about, the standard for what constitutes discrimination. And what the court has said is it only rises to the level of discrimination if you're altering the terms and conditions of someone's employment, and you only alter the terms and conditions of someone's employment if the harassment is severe and pervasive. Now, these cases are a little bit different because no one doubts that the employee has been subject to unfavorable treatment on the basis of a characteristic. They were fired, but the harassment cases are, you haven't fired them, you've just made working more difficult. And the question is, have you made it more difficult to a point where you've either constructively fired them or altered the terms and conditions of the employment? Now, these cases were litigated on the basis that the employers were saying, at least arguably, we fired these employees because of their sexual orientation or gender identity. Now that the court has said, well, doing that is discriminating on the basis of sex, now the employer's defenses are going to be, well, we fired the employee because they were late, they had a bad attitude. And so the discovery is going to come down to,
so these weren't pretextual
actual motive. Right, exactly. Like here, the employer wasn't disputing, we fired these individuals because of their sexual orientation or gender identity. But now that the court has established that discrimination on the basis of sexual orientation is unlawful discrimination on the basis of sex, the cases are going to come down to, well, did the employer fire the employee because of their sexual orientation or gender identity, or did they do so on the basis of some other characteristic? Justice Gorsuch floats because they supported the wrong Major League Baseball team, like Yankees, right? Or, and so that's what the discovery and summary judgment is going to come down to, is basically like resolving this kind of factual question about why the employer took an action.
That's super helpful. I didn't know the facts in that, so thank you for explaining that.
So I want to go to Justice Alito's long list of statutes at the in his appendix. He takes the view that this is going to be a hugely consequential decision in other areas of law because the phrase sex shows up elsewhere other than in Title VII. And since the Supreme Court has now interpreted because of sex to incorporate sexual orientation and transgender status, presumably that has implications for other areas of law. My gut instinct is that that is a little bit mischievous on Justice Alito's part, because the phrase because of sex in the discrimination context doesn't actually mean the same thing as the word sex without because of in lots of other contexts. But I'm open to the idea that this may have second and third order consequences in a lot of areas that I'm not thinking of. So Anthony, get us started. How sweeping and important is this outside of the area of employment discrimination?
So, the first thing when I read this opinion, the dissent from Justice Alito, it read to me very Scalia-esque. And I thought to myself when I was reading it, yes, from your lips to God's ears, make it true, make it so. Because, right, what Justice Scalia did, in my view, was in Romer and in Lawrence, right, he said, well, if you do these things for gay people, all these terrible things will happen, like equal marriage rights. And then lo and behold, when Justice Kennedy said, no, that's not for today, a few years later, oh, by the way, here we are with Obergefell. So, I got a kind of a Scalia-like feeling from this dissent. I think it's true that there are a lot of different federal statutes that now come into play because the analysis is generally similar, right? So now you have Title VII. There is a question now about the Fair Housing Act, which litigation has already been underway as to whether the sex discrimination provisions there also apply on the basis of sexual orientation. Of course, Title IX and educational opportunities is a huge, huge area that is now contested in terms of transgender children's rights in primary schools, and is now actually a huge important, or I should say a huge point of contestation with the Department of Education and affirmative accommodations for transgender athletes. So, and then there's things like fair credit, requirements under federal law, which also have sex discrimination components. So I think it's safe to say that courts should and will look to these decisions when construing those parallel statutes. So I think there's a lot of real opportunity there for the courts to actually to construe those statutes similarly. But how fast that happens, or to what extent the courts will do that, remains to be seen. I do think that there is an interesting gesture to the constitutional question about whether LGBTQ discrimination now gives rise to a sex discrimination claim under a constitutional analysis, and then therefore is entitled to heightened scrutiny, is interesting because it would seem on just a logical perspective, you wouldn't be able to have this decision square with a decision that says, no, these are two different things for constitutional analysis purposes. But of course, Chief Justice Roberts had that opportunity in Obergefell and Windsor and didn't bite at it. So I think there's a lot of open-ended questions on that front mostly. But for now, I think it's fair to say that that just what Justice Scalia or Justice Alito is saying, in particular with the Fair Housing Act and similar statutes like that, there's a lot of hope there that the courts will construe them in a parallel fashion.
Well, it's not hope on Justice Alito's part, we should say.
But my part.
Is it fair to say that the more the statute resembles an anti-discrimination statute, and the more the context of the word sex resembles because of, in the context of discrimination, the greater the likelihood is that the lower courts are going to look at this opinion and take their interpretive guidance from it?
I think so. Yeah, absolutely.
We have a question from Marty Lederman, who is we are in endless negotiations with to be a guest on this show himself. But Marty, the floor is yours.
I am going to defer because Katie's here now, and I want to hear from Katie first. So can we pause? Or do you want to hear? What?
So I'm going to introduce Katie. Katie is a professor of law at Rutgers. She, as Leah previously, was, we were all fangirling your incredible amicus brief that apparently became the opinion of the court, kind of, that you ghost wrote this Supreme Court opinion, for free, apparently, and with for free.
Congratulations.
Yes, congratulations. This is a huge day for you. And so we're thrilled to have you on. Thank you. Thank you to the Twitterverse for connecting us to you. It's Marty, do you have a question for Katie specifically, or did you just kind of want to hear her reflections on the opinion?
It's not for Katie specifically, so I'll be thrilled to hear her first, and then I'll stay in the queue.
Yeah. So Katie, what do you think about the decision? We've kind of been, just to give you a kind of people's take so far, there's kind of been this is huge, but as Anthony kind of points out, this is a bit of a vanilla decision, in some of the writing. Leah kind of points out that they went with a much more formalist approach, and that that it didn't really exactly track with Katzmann's decision out of the Second Circuit. There's kind of the discussion that the trans issue is a lot lower hanging fruit than the sexual orientation issue. Maybe talk about your brief that you filed and how you felt about today's decision and whether you were surprised.
Yeah, I mean, from my perspective, the decision was an incredible win. I think that I was less surprised than many people were, because I've thought all along that to the extent we have anyone on the court who actually ascribes to their textualist principles, this case was a straightforward decision. And I had some faith that we might have some such people, right? Justice Scalia is a great example of somebody who sometimes wrote very progressive decisions in context where you would not have expected that based on his ideology, but based on the textualist principles. And here I really thought the textualist argument was a quite straightforward one. I was also really pleased to see that the court did not go down some of the routes that could have created real obstacles for transgender employees in effectively enforcing their rights in the workplace. I know there were some concerns that they would, have language in there limiting the opinion in the context of things like ability to access a gender identity appropriate restroom, that there would be demeaning language about what sex truly is. And I think that for the most part, the majority opinion really sidestepped those potential issues. I'll also note that a fair amount of the language about but-for causation in the opinion is actually really useful to anyone who litigates discrimination cases, right? It really makes clear that this is a standard where it's basically, you know, the straw that broke the camel's back. If it's changing the outcome, it doesn't matter if protected class status was the main basis for the decision. So I was really thrilled to read the opinion. I thought it was a great opinion. You know, perhaps that's immodest to say since it was similar to reasoning that I put forward. I should also note that the Constitutional Accountability Center, I should give them some serious credit too. They co-authored my brief, so shout out to them as well.
I am always happy to shout out the Constitutional Accountability Center, which was founded by my dear friend, Doug Kendall, who died a few years ago. And I always have it's interesting. I didn't know they were involved in your brief, but Doug's project for the latter, he was originally an environmental lawyer, but his larger project in life was later project in life was to save originalism from conservatism. And the Constitutional Accountability Center grew out of that project, which started in the environmental space. And so it's kind of neat that they were involved with you on this brief. It's a cool thing.
Yeah.
Marty, the floor is yours, this time for real.
Okay, Katie, I don't think this is any occasion for immodesty. I think you should be very, very proud and the like. Let me start with a disclosure, which is that I am Leah's co-amicus, amica. I don't know what the word is.
I hate that.
What?
I've never...
You hate the fact that Leah and I filed brief in this case? Well, we did, and unlike Katie, our views were completely ignored. But I'm gonna come back to that and suggest that maybe it's a good thing, because I actually think that the opinion bodes well for the things that Ben and Katie were just talking about, the restroom and dress code issues that Leah and I wrote about. But I thought I'd start with just a couple of quick points. Maybe you guys didn't know, while you were on, the President of the United States said in response to a question that he has read the decision. So he's read the 170 some pages. And I'm waiting for the follow-up question, which is
in 18-point font, written for him by hand in Sharpie marker.
No,
sorry.
No, Kate, you're confusing literal textualism when he says I've read with
taking seriously textualism.
No, with contextual textualism.
With pirate ship textualism.
Yeah,
right, exactly. And so I'm waiting for the follow-up question, which is what he thinks of the justice's references, and this is for future law exams, Anthony, Leah, Katie, about elephants, baby
And
carriages, donut holes and mouse holes, pirate ships, and the like, right? So we can discuss all of those things which are in the opinion. But here are my couple of questions for you. First, I want to say I agree with Andrew completely. What's really notable about these hundreds of pages of nominally textualist opinions is that textualism doesn't decide how to, textualism doesn't resolve the case. You have here two purported textualists, and as Leah points out, a non-textualist, Alito, fighting to the death about what textualism provides, which I think reveals the poverty of this mode of interpretation in the court, that they couldn't agree. I actually think that Alito's response to Gorsuch is rather effective on Gorsuch's terms, but that it's very vulnerable on other terms. Alito assumes an employer who has a categorical rule, no homosexuals need apply, right? Gay and I discriminate against gays and lesbians across the board. And I don't know that Gorsuch's responses to that hypothetical are all that effective, and Alito gets some points in, I think, on that. The problem with Alito's hypo is that not only didn't these employers have any such policy, but it's hard to find an employer in the United States who has a categorical policy against hiring or insists upon no homosexuals in the workplace. That doesn't exist. What you find instead is employee by employee decisions like the ones in these cases, which are, by the way, based upon stereotypes that are distinct as to men and women, lesbians and gay men. No employers treat them the same. But here are my two questions for you guys. Number one, what explains Justice Kavanaugh's vote? And this is something that's come up in all my conversations today with all my friends on this. This would have been an easy one once he saw where Justice Gorsuch and the Chief Justice were going. This isn't some grand principle case. It's not constitutional law. He's got Gorsuch writing a textualist opinion. He could have easily joined. It could have gotten him some goodwill among people who he might have lost some goodwill with over the last couple of years. It's only statutory, right? It probably reflects, at least if you believe what he wrote, reflects his substantive views on what the law ought to be. And yet he nevertheless dissents. And there are only two explanations I've come up with. One is that he's just not persuaded by Gorsuch's textualism and can't bring himself to join it. And the other is that the sort of the lurking religious liberty questions were affecting him, because I think they're very important to him. So I'm curious what you guys think on that. But the big thing from the perspective of the brief that Leah and I filed, I actually think it's going to be really hard, not impossible, obviously, they can do whatever they want, for this court or other courts to deny transgender employees and students rights to restroom access and to exceptions from dress codes, from sex-specific dress codes, under the reasoning of this case. I think Alito is right. Gorsuch nominally reserves that question, but the logic of his opinion is very difficult. It both preserves the ability of employers to have sex restrooms and dress codes, but also to have to require exceptions for transgender students and employees to those general rules, which is the theme of the brief that Leah and I wrote. And I'm curious whether that's just wishful thinking on my part or whether you guys agree that it bodes well for those questions.
All right, a lot in there. Who wants to talk about, let's deal with, it's blood and guts TV. Let's deal with personalities first and we can get to principles later. Whither Brett Kavanaugh, who wants to take it?
So
I know I don't want to take it. Leah, get us started on Brett.
I was going to say, Katie, do you want to go? And then I'll add some, let's say, snarkier comments.
Yeah, so
more intelligent ones.
I'm not going to get into the motivations. I'm just going to note that at oral argument, it was already clear that he was headed in this direction. The single question that he asked was about the difference between literal meaning and ordinary meaning. There has been some movement among conservative textualists to try to draw that type of a distinction. I think in part because textualism is now being deployed in ways that are progressive, right? As progressives pick up the tools of textualism, it's no longer simply a conservative tool. This sort of, how I view it cynically, is a sort of backdoor route to allowing disfavored applications to, this time conservatively disfavored applications to again be excluded from the law. But as to why Justice Kavanaugh in particular is attached to that result, I will offer no opinion.
So
Leah?
What I was going to say is, as Marty kind of alluded to, and as we have been discussing, there are different versions of textualism, as Katie noted, like Justice Kavanaugh kind of seized on the plain meaning textualism. You ask the person at the cocktail party, has this person been discriminated against on the basis of sex? They say no, therefore that resolves this case. And I think, the choice about which kind of textualism you use is informed by these kinds of extra textual considerations that we're all pretending aren't entering the equation, right? The religious liberty concerns that Marty alluded to, the possible application of this rule to, do you have to provide restroom access, and what happens about single sex dress codes? So those consequential considerations are entering it, as is, right, the general kind of like social conservatism. And so I think that those considerations probably informed his idea and view about which version of textualism he thought was more persuasive here. So it's kind of a combination of all of them. To that, I would add, what goes around comes around, Democrat. And, it's all just a big conspiracy by Hillary Clinton. And like, I don't think he's over that, right? Like his speech at the Federalist Society convention this past year was, I'm always going to remember who stood by me and like who, right, launched this smear campaign. I don't think he's over that. And, I don't think he feels particularly strongly about proving, right, to any of us that like he is the person that, he portrayed, prior to that hearing.
Yeah, I'll just add to that. I think that point is worth a foot stomp. As one of the people who did not stand by Brett Kavanaugh, I don't like the assumption of Marty's question was that this was a freebie opportunity for Brett to reach out and to establish some independence from the club. And as Leah points out, and I think correctly, I don't think there's any evidence that that's what he wants to do right now. And maybe this is a freebie opportunity where his vote doesn't matter to stick with the club and to establish, if he's thinking cynically, and I also don't want to ascribe motive, but if he were thinking cynically, this is a situation where it costs you nothing, your vote doesn't matter, so stick with the club, hoard that credibility, hoard that capital for a different moment. But let's talk about the second question, which had to do with the implications for bathrooms and uniforms. Anthony, you want to take that?
Yeah, so I'm going to push back against Marty's first assumption that there are no institutions out there that have no gays allowed policies, because there are many of them. Many of them are institutions of higher education, or even just religious-based schools. So I think there are a lot of those institutions that do have those kinds of policies. For me, full disclosure, in the amicus I wrote or I co-wrote, we emphasize this idea of sex stereotyping, which I think would have taken care of some of these issues, perhaps with dress codes and the like. But I also think that the straight, textual analysis that the court fashioned today will take care of these issues. I mean, you really just cannot discriminate on the basis of these kinds of stereotypes without taking a person's sex into account. So I think the bigger question is not, for me at least, a Title VII question. It's whether these kinds of principles will be applied in the Title IX context, and whether or not the efforts by the Trump administration to push back against restroom access for children or equal opportunities for transgender children in terms of high school sports or even collegiate sports, and what kinds of accommodations are, in the Trump administration's views, discriminatory in and of themselves. I think those are going to be the harder questions that courts are going to have to adopt or to wrestle with in the future. For me, at least, I think that, again, the straightforward textual application that the court did today, as applied to dress codes and as applied to bathroom access, I think the issue should be fairly, the court should be able to easily allow for those kinds of equitable decisions, because I don't think that the court did what I was afraid of, like Katie spoke about, Katie and Leah both talked about too. The court didn't introduce these kind of inflammatory comments and dicta about bathrooms and dress codes and things like that, which might give other courts some pause. I think it was the decision was a strong enough one that signaled to courts that you really should take these issues seriously, and discrimination is discrimination, even if it's just a small part of the calculus. So I'm hopeful for those cases to be decided in favor of transgender students and transgender employees in particular. And I think the writing is on the wall, at least I think so. But I would be remiss to not also note that even though this case was decided today favorably for LGBTQ employees, there is still legislation that's pending in Congress to affirmatively put these protections into law through the Equality Act. And, so to whatever extent there might be some uncertainties that exist in terms of how this text or this decision today will apply to some of these issues on, as we continue to litigate the peripheries of the issues, I think the Equality Act might well settle a lot of these things if it's enacted and signed into law, next Congress, and if there's a change in administration. So I think we should kind of flag that just to think about how this is not a dead end today. There will be continuing legislative conversations in Congress about how to cement today's decision and clarify some of these outstanding issues.
I just wanted to piggyback on what Anthony had to say about that. For the vast majority of workers, what they want is not to experience discrimination in the first place, not to wind up with the lawsuit that's then going to clarify the legal issue of whether they were properly fired for using the restroom consistent with their gender identity. And so I think it remains really important. I mean, this is a historic decision. It's a really important set of protections, but to continue to push on legislation and ensuring that it is 100% clear to employers across the country what equality rights LGBTQ employees have.
And what's the additional work that the Equality Act would do that this opinion does not do in the employment context?
You can take it, Katie. That's fine.
Yeah, I mean, in addition to clarifying some of the outstanding issues that might exist, it means we would have codified categories in the US Code that specifically say sexual orientation and gender identity discrimination. It also would resolve many of the questions that you alluded to earlier about the extension of this reasoning to other anti-discrimination contexts, because it reaches beyond employment to a whole host of other anti-discrimination contexts.
Leah, I want to kind of ask a very broad question, which was just kind of, I know that there was there was some tipping to like this going this way in oral arguments, but just like generally kind of, I feel maybe I'm wrong and I don't follow the court as closely as you. I am a private law person and do all of this, that's mostly what I'm focused on. So I don't follow this as much, but I just do feel like there has been a lot of things from the court have just been like so incremental, like in the last few years with decisions. I mean, besides Obergefell and a few like other things, or they're kind of walking things back with the Voting Rights Act or things like that. I just kind of felt like this was a big progressive move, and that it was also kind of a strange set of alliances. And in terms of everything, I know we've kind of discussed some of this, but just like as someone who studies and watches the court kind of constantly, were you surprised just from the tone of any of the decisions or the personalities or kind of where things shook out? And do you think that this has any type of, is there generally horse trading on decisions so that like this is going to have the win and this is going to have an impact on future cases that are happening, like that are coming down the pike?
So much to say there. I don't think this decision was unexpected in a lot of ways. As Katie suggested, the methodological moves had kind of already been paved. Justice Gorsuch, as you noted, kind of tipped his hand at oral argument in conveying that he thought the text of the statute more clearly supported the plaintiffs, and what was he to make of these extra textual considerations. In many states, not all of them by any means, but there were already protections against discrimination for LGBT employees. So it's not like this is like a major revolution in how we do things, in contrast to say like a decision saying, I'm going to invalidate the administrative state, right? In some ways, right, this is a very conservative decision in kind of keeping the court apace with kind of majority cultural understandings and like the direction of the law in a lot of ways. And, to Court of Appeals, as Anthony, I don't know why I call you Andy. Anthony noted, had already,
Marty did it too.
Right. Let's blame Marty. That sounds great. So it wasn't surprising in that sense. I do think that there is reason to be skeptical about what this means for the remainder of the court's decisions. I do think that some of the institutionalists on the court think seriously about how the court is perceived as an institution. What does it mean, right, if you have a series of 5-4 decisions or 6-3 decisions that always go the conservative way, right? That is going to lead to a bunch of public commentary saying like the Roberts Court is pushing their ideological agenda, their partisan agenda on a country, right, that doesn't support it. And decisions like this, right, validate the idea that the justices' interpretive methodologies are separate from and different than, right, their underlying political commitments. So that is, in a lot of ways, a huge boon to justices who want to preserve the institutional credibility of the court while also doing the things that they think the law requires, which are often conservative ends. We are waiting on decisions about the legality of the Trump administration's rescission of the Deferred Action for Childhood Arrivals program. We're awaiting decisions on the legality of Louisiana's admitting privileges requirement, the abortion restriction that is identical to Whole Women's Health versus Hellerstedt, the restriction the court invalidated there. We are awaiting decisions in Espinoza about the legality of school funding. We're awaiting decisions about the contraception mandate, religious exemptions from non-discrimination statute, presidential immunity, the lawfulness of the Consumer Financial Protection Bureau. And I think this decision, in a lot of ways, gives the court cover, right, for if it reaches conservative results in those other cases. Now, would there be explicit horse trading? I don't think the justices often allow themselves to explicitly think in those terms or like engage in those interactions. But I do think, right, it does make it easier for an institutionalist to say, well, am I damaging the court's institutional credibility with this string of decisions? Probably not.
It's a really wonderful explanation. Thank you for that. Yeah, that was awesome.
So we have, we should wrap up.
Chris's question is very long.
But Chris's question is an interesting one. And so I'm just going to read it rather than bringing him in. He says, to piggyback a little on the discussion just now, while the ruling that came down today is made in the context of employment, does it have any impact on the way that sex discrimination in Section 1557 of the Affordable Care Act can or will be interpreted? We learned last week that the Trump administration intends to roll back transgender protections under the ACA by interpreting sex discrimination as only applying when someone faces discrimination for being female or male, or at least that is how NPR describes it. Does today's decision change the viability of that position by the Trump administration? So I'll let Anthony close with this, but my instinct is that, to go back to our earlier discussion, this is one of those situations where, on the one hand, it's clearly the word sex is clearly showing up in the discrimination context, and that means it will be to some degree informed by this. On the other hand, sex discrimination as a phrase is not the same as because of sex and doesn't necessarily invoke the same but-for causation discussion that is central to Gorsuch's decision here. So I'm curious, should we expect that that something like sex discrimination in the Affordable Care Act will be interpreted meaningfully in light of this opinion? It's a great question.
So the way I see it is that this is kind of like the Trump administration just built a sandcastle, and today the Supreme Court was a big gust of wind that toppled it down. I don't think that their position is defensible in light of what the Supreme Court said today. Now, does that not mean that courts can't find distinguishing characteristics, to what the Trump administration is trying to do in light of the ACA's requirements? Certainly courts could find distinguishing features to say, well, that's different, and so we're going to rule against, transgender plaintiffs here. I think that would be intellectually indefensible, though. I think really what the court has said is that when you have a non-discrimination statute and sex discrimination is the issue, you cannot discriminate against someone because they're transgender without looking at their sex. And so to try to retwist it and reinvent the term what that, the interactive effect between sex and gender identity is. I just don't think that that's a defensible position as of June 15th, 2020. But again, I think courts can. There's plenty of wiggle room for courts to try to just to put some light between what the Trump administration is trying to do with the ACA and what the court did today with Title VII. But I think it's a much harder hill for them to climb than it was yesterday.
I just wanted to add, I don't have the language in front of me, but I think 1557 uses the language on the basis of, which the Supreme Court has treated as entirely analogous to because of in terms of its significance. So if that's
interesting. So the quotations in the question were in a different place. But maybe that's because he's quoting the news story rather than the statute.
Yeah, well, 1557 is modeled on Title IX, but the court has interpreted, and HHS has interpreted like Title IX and Title VII to mean kind of the same thing.
I see. So
on the basis
if that's the case, that would make it very difficult to distinguish them, I would think.
Yeah.
We're going to have to leave it there. We went from a day with a big lacuna filling in lieu of fun, where we had literally no idea what we were going to talk about, to one of the richest and most timely discussions we've had on the show. So thank you all for joining us. And Kate, thank you for wrestling everybody up.
They're all like, all of these people are just like wonderful, brilliant people. Have them on NPR, have them on CNN.
I was in my morning editorial meeting for Lawfare. By the time I got out of it, Kate had us a show. It was incredible.
Kate brought some Katie Porter's whiteboard energy
in lieu
of fun show.
It was fucking fabulous. Thank you all. And we have no idea what we're doing tomorrow, but maybe the Supreme Court
will give us another opinion.
Rescue us from that too.
Maybe the president will live tweet his reactions to this opinion.
There you go. Exactly.
I don't know.
We're going to play it by ear and see what happens. And until then, Kate.
We don't have fun anymore. So in lieu of fun, come hang out with us and talk about the Supreme Court.
Yeah, but don't
Katie,
discriminate.
Congratulations on your incredible day. And thank you both of us for joining us. Ben.
And remember, everybody, don't discriminate in employment decisions anymore against gay, lesbian, or transgender people, because that will incur liability, unlike yesterday.
Thanks,
See you tomorrow.